Okay, hello everybody. This is Dr. Rob Kirkland, Associate Director for Graduate Education here at CSU Global. And I'd like to introduce to you today Dr. Christopher R. Zapalksi. Christopher has been a professor at CSU Global since 2010. He's a graduate degrees are Masters of Law, Doctorate of Law, Masters of Business Administration, Master of Public Administration, Master of Human Resource Management, and Master of Information Systems Management in Criminal Justice. And of course, his area that he teaches for Global, a Masters of Accounting. His doctoral education is in finance. For professional activities, Christopher is an accountant, attorney, and business consultant practicing in the areas of tax and federal law. Christopher holds a bar membership in Florida, the District of Columbia, and the U.S. Tax Court. Today, Dr. Zapalksi will be talking about China's patent system and do they keep their promises. So without further ado, I'll introduce to you Dr. Zapalksi. Dr. Zapalski, thanks.
All right, well, welcome everybody. If you do have any questions or concerns that you're watching this remotely, you can contact me through the CSU Global Directory, and I'll be delighted to answer any questions you may have. The one thing I want to talk tonight about is China's patent system. This is a series of lectures that and research projects that I present. And the major component is how does China react to various intellectual property systems? And the system we're going to talk today about is the patent system. So let's give you a little bit of brief history of China. And before 1949, the Qing dynasty issued patent law. And that lasted from the history till after 1949, and until 1978, there was basically a blank period where there was nothing. And that's probably where a lot of our jokes come in about China not actually having a patent system and maybe cannibalizing the United States or other parts of the world. But in 1979 to 1990, all the other countries in China got together and formulated a primer for the patent system, which I actually have another presentation that I've completed on that, which is a patent primer for China. So if anyone's interested, I can forward that out. And from 1990 to present is a development period, and that's what we're having today. So if I just give you a little bit of generic feedback on this, basically in the founding period, the laws were being issued, the laws were being written. However, it's not until the development period today that they're actually being serious and consistently enforcing the law. So what is the status of intellectual property system? Established a legal system for intellectual property rights suitable for Chinese environment and in accordance with international rules. The establishment is a working system that includes administrative approval, promotion and training, intermediate services, academic researches, and various other components. It established administrative and legal systems with a parallel law enforcement system of intellectual property rights. And in recent years, the number of applications of Chinese trademarks, utility patents, and design patents continue to be the largest in the world, while the number of applications for inventions patents is ranked 4th in the world. So before I talk about the actual sections of the law, let me assume that none of you know anything about a patent. A patent is not a right to make something. A patent is the right to preclude or stop other people from making your item. For instance, if I come up with a patent, I may actually use several other people's patents in my patent. So it doesn't necessarily give me the right to make what I want. It just gives me the right to stop other people from making my patent. For instance, if I create a car, let's say I call it the Chris car, and I decide to go with a Ford Motor Company Coyote Mustang motor in it. Obviously, I'm going to have to get the licensing agreements from Ford to put that that motor in it among maybe the brake manufacturers, tires, so on and so forth. Without their permission, I can't make the car. However, if somebody else wanted to make a Chris car or specs that were strikingly similar, they would need to obtain a patent. So that's very important. So this slide here talks a lot about what the progression of the law is and how it moves forward. So the 1984.03 patent law in China, the patent law of the People's Republic of China, hereinafter the patent law, was promulgated on March 12, 1984, marking the foundation of a patent system in China. It went on to force on April 1st, 2005, opening a new chapter in history in the China's patent system. And the reason is people weren't going to make in China if they knew as soon as they got there, their inventions were going to be stolen and pirated. So in order for a company to want to manufacture there, they're going to need a stable law. In 1992, the patent law was amended on September 4th, 1992. This amendment brought expanded content for long duration and strengthened the protection of the patent rights. The amended patent law and its implementing regulations entered into effect on January 1st, 1993. So now in 2000, the patent law was amended for the second time in 2000 and made it in better conformity with the TRIPS agreement, which is a various intellectual property system that most civilized nations use, as well as the World Trade Organization, laying out an improved legal climate for patent China's accession to the WTO, and the amended patent law and its implementing regulations that took effect in July 1st, 2001. You know, without these treaties, and the treaties are not ironclad enforceable, but they do lie precedents, you basically need to get a patent in any country that you expect to do business in, or at least think that your product's threatened in. And obtaining one here in the U.S. doesn't prevent various countries from making products, or their companies making products there. It's very important that you research how exposed your product will be. Yes, we do have treaties with other nations. However, taking a foothold in 100 nations may just be cost prohibitive for your organization. So the law went to expand a little bit more. In 2008, the decision of the Standing Committee on the National People's Congress on amending the patent law of the People's Republic of China was voted through the sixth session of the 11th meeting of the NPC Standing Committee on the 27th of December 2008. The revived patent law of the People's Republic of China came into force as of October 1st in 2009. And the Third Amendment to the patent law, featuring reinforcement of the legitimate rights and interests of both domestic and foreign applicants. The decision of the Standing Committee of the State Council on amending the implementing regulations of the patent law of the People's Republic of China was voted on through the 30th of December of 2009. The draft improved the secrecy examination system of the invention creation completed in China, pursuing an overseas application. It supplemented and detailed patent application procedure and granting criteria. It clarified the disclosure requirements for genetic resource information and the administrative punishment of patent infringement. And the amended implemented regulations came into force the 1st of February 2000. So based on that, they have the law. So let's see how the indicators of the Chinese patent move forward. There are three types of patents: an invention, a utility model, and a design. An invention is something new. Maybe we haven't even thought of it yet. Utility model is a use of something, how something is used. Maybe a system, like how you order a product or operate a vehicle. A design is much like a trademark. It is a patentable functionality of a symbol. Maybe the way that a Coke bottle looks or a Red Bull can. Those could all apply in that regard. Maybe the design of a hood of a car or a symbol that's not protected by trademark. Being that this is just a patent lecture, trademark law would go hand in hand with design patents. However, that's for another topic. If you're interested, again, reach out and I will be delighted to flood your inbox. There are 5 types of applicants: enterprise, universities, research institutions, associations, and an individual. The indicators include basic patent indicators, statistics and survey indicators, and evaluation indicators. The basic patent indicators are the number of applicants, the number of granted patents, and the number of owned patents. Statistic and survey indicators are usage, rate of a patent, licensing rate, etc. Evaluation indicators: completeness evaluation, management capability evaluation, and the quality of the patent evaluation. So in this case, we see that patent applications in China are on the rise. The wheel in the upper right-hand corner lists the percentage of each. And if you'll notice, they're pretty close, all 3, aren't they? Design patents just being slightly less. And if you notice towards the latter years of the chart, the design patents are even starting to level off a little bit more. So be interesting to see where things take us. And the applications ranged from under 50,000 in 1991 to over 300,000 in each of the categories today. And for invention patents, approaching 400,000. Among the top 5 countries for invention applications, Japan filed more than 1/3, and the US filed about 1/4. So of the invention patent applications, you see the various countries posting their volume. Between 2006 and into the future here, you can see there's a big rush in a lot of the major countries and how they apply, how the trend applies. And eventually, and probably merge and quiet out, because once the patent information was available, I'm sure a lot of the companies made a mad dash to get their information. Now, we looked at the patent applications earlier, but what about the granted patents? In this case, granted patents a year, started from just a few thousand to between 60 and 70,000. Just because you make an application doesn't mean it's approved, because your application could be infringing upon other people's. So there's a rigorous process, rigorous legal battle, rigorous justification. So in the end, you see those 400,000 dwindle down to maybe just 100,000 or so. And as you can see, each form of patent is on the rise. However, the utility patent seems to be taking the jump. As an enforceability. As you can see, the applications are on a striking rise, and it seems like they're almost rising exponentially. There are a few patent applications by the Chinese company in foreign patent offices. So we're taking the reverse. Till 1999, they averaged less than 300 applications a year around the world. 2000, it went to about 1,000 applications, and now they're hovering around about 10,000 or so. And patent applications in the patent office per million inhabitants in the Chinese, less than 5, but in developed countries are over 50. So China tends to be a little more inside their country, and I would say that may have a lot to do with the restrictions placed on by their government, being that it is a communist, socialistic society, that the people in China have less freedoms than we have here in the United States, and apply for something in another government may open that company for risk, because if one of their major companies is putting patents in the US or Japan or somewhere else, there may be a risk for that company to leave China, leave the grip of control of the government. So, the restrictions there are broad, or more not broad, but strict. There's 17 There are 17 randomly selected patents of both the U.S. and China. These domestic patents for U.S. and foreign China, and all patents were awarded as of December 31st, 2015. And this is our sample size for our research. So we're checking again the enforceability of the patents out there. So we know China has a robust system today. We know their laws are developed. So if I have patents and I'm operating in China and somebody infringes upon my patent, what's the probability of me being able to curb that behavior? Because, believe it or not, there are a lot of things out there. I heard one of the battery manufacturers that I was advising would say that after hours, they would run their batteries on the same lines. And their batteries would look the same. Let's say it's X-side. I don't know what the actual brand of the battery was that I want to talk about, but let's just say it's an X-side battery. The knockoff battery would actually have X-side on it, but when you reach down to grab the battery, it was much lighter than the other one. Probably it has less, amp watt hours or whatever, or storage capability. And I remember I was working in the automotive industry, and there was some oil that was purchased, and the oil was purported to be a name brand oil. But when we got the oil and we opened up the can or the bottle, started to pour it, I was like, what is this? Because the oil didn't come out like oil. And, many people might not realize that. If you're a car person, you know what oil's viscosity is, what we call it, looks like when we pour it out of a can or a bottle. But this came out like water. Now, it was some sort of petroleum-based product and probably would mix nicely with the oil you have in your car, not to cause any damage, but it was not oil. And, that was very troublesome, because companies can get in real big trouble, maybe with a lawsuit or even damaging their reputation. And they're not even doing anything wrong because somebody else is infringing upon their patent. These are domestic patents for U.S. and foreign China, and all patents were fully awarded. So keep that in mind. So the time to issue a patent in the U.S. The average time is measured from the application submission to approval. The average time is 618 days. And the standard deviation of the patent that we figured out in the study was about 91 days. So the mean was 618 days to have a patent fully awarded, and the standard deviation was basically give or take 3 months. So virtually everybody got a patent between a year and a half and 2.5 years, if you extrapolate out that. the standard deviations. Time to issue a patent in China. The average time measured from the submission of the application to approval, the average time was 605 days with a standard deviation of 34 days. So it seems to be that in China, that 2-year mark, give or take a couple days, tends to be about what it takes. And it could be that there's holding periods or administrative process that you just may need to physically squeak and push through. In the USA, there were not any infringement actions filed on any of the 17 patents explored. In questioning the patents, 4 of the 17 were found to have reasonable threat of infringement. In China, there were 2 infringement actions filed on any of the 17 patents we explored. And in questioning the patents, 8 of the 17 were found to have reasonable threat of infringement. So when I say filed, that means a formal lawsuit's filed before the courts. Reasonable threat means somebody's probably going to take it. You know, sometimes companies just let it go. As an intellectual property attorney myself, I get a lot of calls that somebody's violating something. And I get a lot of nasty threats from the other side that somebody's violating something. And believe it or not, a lot of the attorneys don't know anything about patent law or copyright law or so on and so forth, just enough to get their feet wet. And I usually get some letter in the mail saying, you know, stop doing what you're doing, blah, 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 this is it. And then I usually respond by explaining to them that I am an intellectual property attorney, and here is how way I view this situation. And believe it or not, 9 times out of 10, the conversation stops there. However, it doesn't mean that we don't have a threat of losing it or somebody else using it. So that's the key. So the status of Chinese patent litigation were broken down into 2 cases. Case 1, the first case did have infringement occurring on the manufacturing of the product in question. Once the infringement was discovered and the authorities were authorities were alerted, the company was disbanded. So basically in China, you have a lot of shell companies, and they start stealing people's ideas and patents and making things. And as soon as you call the police, they scatter like an anthill or other bugs entering your house. Case 2, the second case, is still in the initial stage of litigation. The company accused of infringing has been poised to defend the lawsuit based on legal defenses. And believe it or not, there's a lot of legal defenses, and that's why it's paramount to have that attorney that's able to look over the documents. So that's very important. All right, and that is my lecture today on the Chinese patent system. So is there any questions or concerns that any of you guys have?
Yeah, hi, Dr. Zapalksi. You're manufacturing something in the U.S., and I've been told, like, for example, that golf clubs, I've heard that basically you develop, your golf club patent in the United States, say Callaway or Ping.
I was actually, when I used that oil example, I was going to use that same exact example. I was going to say that, Callaway has a huge problem with people stealing their clubs and sending them back over here as like aluminum casts instead of, a tungsten cast or whatever,
Right. And so that's what I had heard. I heard that, like, basically you run into a situation where, as soon as you manufacture something and put a patent on it, within like a month, it's already being manufactured in China and ripped off.
What you're describing there a lot of times is more of a copyright infringement.
Okay.
Because those companies are not necessarily stealing the functionality of the golf club. They're stealing the idea of people wanting to buy that brand name golf club. So what they do is they take a product that they have and make it look like the product, not caring at all about the functionality of the way it hits a golf ball. They just want you to be able to see that it, in your bag, it looks the same. So it's more of a trademark issue, or it could be a design patent issue.
Right. Yeah. So it's sort of like Rolex, like Fulex watches instead of Rolex watches, right? Where you,
Romex.
yeah,
You remember from planes, trains, and automobiles?
yeah. So the second part is, let's just say there is a patent infringement for what you're doing. What steps do you take as a U.S. Based corporation or person in order to stop the patent infringement in China? What specific steps do you need to take, and how difficult is it to stop the patent infringement?
The major factors are, alerting the authorities and alerting the courts, getting an injunction, and then having the authorities again willing to enforce that injunction. An injunction meaning stop them from doing what they're doing. So in the grand scheme of things, a lot of times companies have to grease palms that may not be as ethically clear as we do here in the United States. And the big key, though, if you ask me what would I advise a company, you need to build a relationship with that enforcement authority through various means. So when there is an issue, they will enforce your right almost even before you even have a judge saying to enforce your right. Basically, if you're friends with the police, and then also, you want to get in good with local governments because they have a lot more property control than we have in the United States. So if you have friends that are as the mayor or the city councilman equivalent in China, and your company is offended by somebody taking your stuff, those people are going to take it as a personal attack, and they're going to make sure that their friends are taken care of. So, that is the secret there. I would say if you're just a small company and you're trying to make something, it's probably going to be hard. You're going to have a physical presence over there, but that is one of the risks that come into play. But now another way you can stop this, though, is that you may not be able to stop what they're doing in China, but you could stop what we call green market goods at the border. So if you're aware of certain things coming in or certain things on eBay or certain things for your suppliers, in the United States, you can take charge of your own patent and not let those goods even enter the U.S. market, okay?
Yeah, that sounds good. I have another question for you. It doesn't necessarily, may not necessarily apply to China directly, but what are the lessons that have been learned out of the conflict between Samsung and Apple regarding patents? Has there been anything that has come out of that that we can apply to what you mentioned today?
Well, what you have, that's an interesting case because Samsung is the #1 supplier of Apple. So basically you have a successful brother attacking the brother that works for them, if that makes sense, okay? And then the brother that works for them also has its own business. So a lot of the patent litigation against Samsung is to stiff arm their negotiations with Apple in making future products, okay? So like if I let you make something and I don't put pressure on you, are you going to give me a better deal when I need memory chips or circuit boards soldered? So those are some of the issues that Samsung and Apple will have behind it. Now, Apple, obviously the big case is, it is a design patent issue. It is a utility patent issue, and to some lesser of extent, it's an invention patent, but it doesn't take any genius to realize that a multitude of companies have stolen the interface of Apple in interacting with a touchscreen device to make phone calls, browse the internet, have apps. Samsung has Apple Pay or Samsung Pay, and they don't Samsung doesn't even try to disguise it. The Apple calls their big phone the iPhone Plus, right? And they were calling it the Note until it turned into a furnace. But now the big phone is called the Samsung 8 with a plus sign. So the naming conventions are just directly stolen. So that is the issue. But I'm going to step outside of patent law for anything. You need to have a competitor to make your company better. Anything that's stagnant will stay stagnant. You know, if there was no competitive phone market, we would still have an iPhone 1 if we have an iPhone 1 at all. So, you know, it's also healthy for the industry to have somebody pushing them. You know, and keep in mind, as Samsung is a large supplier of Apple, they know exactly what Apple's going to make before they make them. So it's really easy for them to do that. So, again, these enforcement actions are designed to solicit licensing agreements, to solicit manufacturing processes, not to necessarily stop somebody from doing it. And if you look at a lot of those, you know, they're not saying stop using this product. Now, the one thing that did have an impact was a Canadian patent case here in the United States against a company called RIM, which was Research in Motion. And they had a mail system that was found to be infringing upon somebody else. And Research in Motion didn't really have a big enough foothold in the market from a global perspective. So they weren't able to reach some sort of licensing agreement with the owner. And I don't know if you remember that back probably about maybe 2004, 2005, the BlackBerry had to like change its entire push notification system process away from what they were using. So, you know, that's a tricky case. I wouldn't probably use that as a pure form of, you know, Apple and Samsung. It's just more of a battle of the licensing and who gets a piece of the pie more over than that. I wouldn't say it's a precedent case in terms of defining patent law. With the rise of nationalism around the world and countries starting to want to make their products back in their home country, that will only help this process because, you know, right now it's so cheap to make things in China that the companies are willing to just throw away technology at the expense of getting that product made, or the lack of expense in getting the product made. But if the wages and everything are more competitive with, let's say, the United States, then in order for China to keep its production facilities, they're going to need to offer a more protective environment. So that's just one thing. And you see that, you know, getting cyclical around the world, you know, it seems to be a common trend. So, you know, everything comes back to one point or another. So, you know, we're just probably, you know, the current administration's policies are a lot like the FDR, if your parents can remember that. So, you know, what, you know, Franklin Delano Roosevelt did economically, that's kind of what we're seeing in Washington, not Washington per se today, but at least at 1600 Pennsylvania Avenue. I believe that's the White House address. So, you know, keep that in mind as you look at how patent law is moving forward. And remember, these are regulations, these are political processes. So you always want to follow that. So don't be closed-minded to what's going on around you, because everything, you know, come down to if a voting machine works in North Carolina could affect how a patent, you know, is awarded in China. So just keep that in mind.
Well, great, Dr. Zapalksi. Thank you so much for those comments. And we very much appreciate you taking the time out of your day to give this very interesting presentation to us. So thanks so much.
All right, take care.
Okay, thank you.